an NAACP who wants to stay relevant, or a Barack Obama who wants to get elected, they have a very selective view of which histories they're going to discuss. But you need honest thinkers out there giving people the full scope of black history, which is more than a history of what whites have done to blacks. That's not the sum of black history in this country, but you might think it is listening to some on the left discuss our past.
It's about people who want to redress the past. The only times over which we have any degree of influence at all are the present and the future, both of which can be made worse by attempts at symbolic restitution among the living for what happened among the dead, who are far beyond our power to help or punish or avenge. Any serious consideration of the world as it is today, around us today, must tell us that maintaining common decency, much less peace and harmony, among living contemporaries is a major challenge, both among nations and within nations. To admit that we can do nothing about what happened among the dead is not to give up the struggle for a better world, but to concentrate our efforts where they have at least some hope of making things better for the living.
Dr. Thomas Sowell.
The phrase that you're so desperate for grievances that you have to go back into history to find them, that really says something. It pays off, they're going to keep doing it. What's painful to me is how few people there are today who bother to check out the facts. In many cases, just the smallest effort at checking out the facts would cause so many of these things to fall apart.
See that what you're being told over and over again by mainstream media and print news is not the whole truth. It becomes painfully obvious when you do your own research that what the general public is being spoon-fed night after night, article after article, is actually not reality. All I want to do is give you the information that's being left out, purposefully. And it's being left out because it doesn't fit the mainstream media narrative. So let me just present some things that are casually left out of everything you're seeing. And you guys make your own decisions. I'm not saying this, that, whatever. Just make your own decisions. But I think it's important that we have all the information. Would that be something we can all agree on? Cerruti attended Howard University as an undergraduate and then entered the Brooklyn Law School, from which he graduated in 1911. In 1912, Burton came to Los Angeles and began the practice of law as a criminal defense attorney, which brought him some notoriety and success. In 1913, Dubois visited Los Angeles and met with Cerruti, John Somerville, the first black graduate of USC School of Dentistry, Charlotte and John Bass, who operated the California Eagle newspaper, and others. From this meeting came the next year the founding of the Los Angeles chapter of the NAACP, and Cerruti began to turn his law practice towards civil rights litigation. From 1915 to his death in 1927, Cerruti filed lawsuits in Ventura, Los Angeles, San Bernardino, and Riverside counties on behalf of citizens claiming they had been discriminated against by government action in some way. By 1924, he was the face of the NAACP in Los Angeles, and as far as the black community was concerned, he was their champion of justice. And in that capacity, he was called upon to evaluate the conduct of the city of Manhattan Beach in passing the ordinances Senator Bradford of our day whined so loudly about as evidence that the city robbed the Bruces of their property with the intent to drive them out. Echoing Bradford's claim, Hidley Stern puts the case in her report this way. A resident discovered a legal means by which to shut down the Bruce's Resort through the Park and Playgrounds Act of 1909. He and several civic leaders circulated a petition for support of this action and presented it to the board on November 15, 1923. Hidley is a Georgetown Law School graduate who obviously is just ignoring everything she learned at Georgetown. On the one hand, she tells us that the condemnation process was a legal means, but on the other, tells us this legal means was intended as a device to shut down the Bruce's Resort. But in fact, this legal means did not shut down the resort. How the Bruces wished they could have moved their resort a couple lots north or south and been in business as long as they wished. The objective proof of this is the fact that the Slaughters did exactly that. Literally, the week the Bruces moved out, the Slaughters were open for business that same week, doing exactly what the Bruce Resort did. Nobody was run out of town. These are the Slaughters sitting with Charles Bruce the week that the Bruces decided to move elsewhere. So Charles Bruce is probably here giving them advice what to do and how to run their resort now that the Slaughters have taken over the business. On January 3rd, 1924, the board passed Ordinance 263, claiming eminent domain for a public park. On June 19, 1924, the board enacted new laws with fines and penalties for violating Ordinance 273 to 275, which prohibited new or additional development of bathhouses east of the red car tracks, and also the dressing and undressing in cars, tents, and temporary structures. During the June 19, 1924 meeting, the board also passed Ordinance 276, which repealed Ordinance 263 and indicated the intent to acquire blocks 5 and 12 of Peck's Tract by condemnation. On September 18, 1924, the board received protest from 329 lot owners. The board rejected the protest. On October 16, 1924, the board passed Ordinance 282, which initiated legal proceedings for acquisition of public park purposes of Block 5 and 12. In November 1924, the city filed suit in Superior Court against the 31 lot owners. 5 of the lot owners were black people, and yes, very true, 5 of the lot owners were black. But why did you not let us know that 25 were white? Okay. The verdict-driven nature of Hidley's report is evident from her choice of language and from the contrast of what facts she includes in her presentation and what she leaves out. The objective reality of the case in light of the law is plain to see. The board members decided that if the city was to have open space as a public park west of the tree section, action had to be taken to acquire the space from the only relatively undeveloped land in the city that was left, which was Peck's Tract. To understand the actual reality of development at that time, you need to examine the plat map showing the lots as they existed north of Marine Avenue. Doing so will bring you to the conclusion that it was logical for the board to choose blocks 5 and 12, as these blocks sit right in the middle between Marine Avenue and Rosecrans Avenue, the northern border of the city. Hildy does not inform you that the board members who voted in January 1924 to declare the city's intent as required by law to condemn the blocks were totally removed from office in an election that occurred on April 15, 1924. The result of the election was to install a brand new group of board members, and these new board members reaffirmed by passing Ordinance 276 the city's intent to condemn it. And it was these men who in November 1924 authorized the city's attorney to file suit against the 31 lot owners for the purpose of obtaining a court judgment authorizing the taking of the lots. And second, to provide the just compensation for the taking as required by law. Hildy, in her retelling of Robert Brigham's take, fails to recognize the objective legal reality that in its taking, the city did not discriminate against the black lot owners because of their race. Knowing better, Hildy, as did Brigham, point to the fact that one or more of the board members may have harbored in their minds at the time they made the decision to condemn feelings of racist hostility towards black people. What Hildy certainly must know, in contrast to Brigham, however, is that evidence of the board members' subjective feelings are irrelevant to the issue of the government's discrimination. That what is relevant is whether, in fact, the government's actions objectively discriminated against the black lot owners because of their race. Hildy ignores this reality because she knows if she admits it, she admits her case. It's gone. Brigham's and Bradford's rest on nothing of substance but air. At least you would expect a Georgetown Law School graduate to know this. To hide the ball, that is, distract the audience from the indisputable truth, Hildy waves in your face the irrelevant fact that the white men who were members of the Board of Trustees of Manhattan Beach were no different in their attitude towards black people as the majority in America 1924. That she can establish this, however, does not provide her with a legal basis to establish that. In fact, the government acted in a discriminatory manner towards the black lot owners. It can't do it. The black lot owners received the same measure of just compensation as did the white lot owners. The black lot owners were free to purchase different lots within the adjacent blocks of Peck's tract if they wished, and all of them did, except Willett and Charles, who being in their 60s, used their compensation to purchase 2 homes outright, one for themselves, one for their son, in what was a reasonable affluent neighborhood within the Los Angeles community. They also invested in a few businesses which didn't go very well. Let's move on. Having stated her case, Hildy then acknowledges the fact that in July 1924, Willett and Charles Bruce obtained the advice of Burton Cerruti, the most respected and experienced black trial lawyer practicing in Los Angeles in 1924. Here is her choice of words in introducing Mr. Cerruti's to her audience. The California Eagle newspaper printed a letter from E. Burton Cerruti on July 11, 1924, wherein he stated that Mrs. Bruce was willing to sell her property, and even if a suit be instituted, would sell at a fair price at any time, and would abandon the suit at such time. Here, by her choice, how to present Cerruti's letter, Hildy exposes herself as the not-so-honest politician she is. For she intentionally leaves you in the dark about not only how Cerruti came to write the letter, but also what his legal opinion was. The issue of whether or not the Bruces had a legal basis to establish what Branford thunders happened, that the city of Manhattan Beach robbed the Bruces of their land, robbed them of their business, robbed them of their legacy, and most important, robbed them of their dignity, forcing them to work the rest of their lives for someone else.
1924 as stated, the Manhattan Beach Board of Trustees seized the land, condemning it under the guise of building a public park. The Bruce family was robbed of their land. They were robbed of their business. They were robbed of their legacy, but most importantly, they were robbed of their dignity. They were forced to move and live the rest of their lives working for someone else, all because of the color of their skin.
In fact, the records show it was Charlotte Bass in her California Eagle newspaper who called upon Burton Cerruti to examine the facts of the condemnation proceedings, including the effect of the bathhouse restriction ordinance, and tell her readers with his legal assessment of the matter was this, with the entire black community of Los Angeles knowing that it was this lawyer more than any other who for 10 years has aggressively attacked government racism in court. Whether the matter of discrimination involved a black person refused a seat at a downtown lunch counter, or denied access to a city swimming pool, or refused employment, or boxed in some other discriminatory way, Burton Cerruti spent weeks of his time appearing in courtrooms in almost every one of Southern California's counties on behalf of these persons. Here's the actual letter Burton wrote, which Hildy hides from her audience, the lawyer's legal opinion. Actually, everyone hid this. The news organizations, everybody. This is what the California Eagle posted. Now, this is not Mr. and Mrs. Bruce's fight, but the fight of the people. The NAACP and all organizations should look into this matter and see that Mrs. Bruce is given a fair chance. Matter regarding Bruce's Beach. To the Board of Directors, LA Branch, NAACP. In reference to the matter of Bruce's Beach, referred to this office for an opinion, permit me to advise that an investigation shows that Mrs. Bruce property is not strictly beach property. Mr. Peck, being the owner of the land, intervening between Mrs. Bruce and the water. So far as has been ascertained, 2 ordinances passed by the City Council of Manhattan Beach. 1, condemning the property under consideration for the park purposes, and the other zoning it for residential purposes and disallowing bathhouses and other businesses in that territory. These 2 ordinances conflict, but it is likely that the former will be abandoned and the latter sustained by the council. Ordinance and is not intended to be a party of the suit. She is willing to sell her property and, even if a suit is instituted, would sell at a fair price at any time and would abandon the suit at such time. The Pacific Electric Railway track runs between the Bruce property and the waterfront. My legal opinion, based on the foregoing premises, permit me to advise: 1, that the first ordinance might be defeated in a proper court action, but since it is likely that this ordinance will be abandoned, a suit is not necessary. 2, the second ordinance, zoning the district for residential purposes, is more formidable, and it is possible that we would not succeed in an action to declare it invalid. since bathers from the Bruce property would necessarily cross the railroad track to reach the water. It is likely that the danger ensured in crossing and recrossing these railroad tracks would be advanced as the ground for the enactment of the ordinance. Though we believe the ordinance to have been inspired by other reasons, this excuse would be considered very reasonable and sufficient to sustain the ordinance. Neither this association nor any person could bring an action to set aside either of these ordinances unless they had vested interest in the property involved. Such action must be brought in the name of Mrs. Bruce or some other landowner there. Since Mrs. Bruce is unwilling to institute an action and would not hesitate to drop one if a fair price is offered for her property, it is inadvisable for this association to undertake such a suit. Finally, your attorney regards the beach situation as a financial problem rather than a racial one. He is convinced that any person or association having sufficient money to finance the venture can obtain suitable beach frontage for a bathhouse and other business ventures. Respectfully submitted, E. Burton Cerruti. So let's read that last paragraph again. Finally, your attorney regards the beach situation as a financial problem rather than a racial one. He is convinced that any persons or association having sufficient money to finance the venture can obtain suitable beach frontage for a bathhouse and other business purposes. Regards the beach situation as a financial problem rather than a racial one. Amazing that person Hidley, elected by the citizens of Manhattan Beach to protect them, is so willing to leave out information that would benefit the city of Manhattan Beach. She's leaving out information to make herself look better and to further her own political agenda, while leaving the citizens out to dry, being known as racist. It's not right, it's not fair, and hopefully the next election people will show their grievance.